Protection of Children from Sexual Offences, Pocso Act 2012. 2012 ആണ്. Introduction. This act has been drafted to strengthen the legal provision for the protection of child from sexual abuse and exploitation. Sexual offences are currently covered under various sections of IPC. The IPC does not provide all types of sexual offences against children. More importantly, does not distinguish between adult and child victim. Pocso Act defines a child as any person below the age of 18 years and provides protection to all children, both males and females, under the age of 18 years from sexual abuse. Offences and punishment. Penetrative sexual assault. A person is said to commit penetrative sexual assault if he penetrates his penis to any extent into the vagina, mouth, urethra, anus of a child, or makes the child to do so with him or with any other person, or insert any object or a part of the body, not being his penis, to any extent into the vagina, urethra, anus of a child, makes the child to do so with him or any other person, or manipulate any part of the body of the child so as to cause a penetrate into the vagina, urethra, anus, or any other part of the body and the child, or makes the child to do so with him or any other person, or apply his mouth to the penis, vagina, anus, urethra of the child, makes the child to do so with to him or any other person. Punishment. Imprisonment for more than 7 years, which may extend to life. For aggravated penetrative sexual assault, imprisonment more than 10 years, which may extend to life imprisonment and fine. Sexual assault. Any person contact with the sexual intent but without penetration, like touching the vagina, penis, anus, or breast of the child, and make the child touch the vagina, penis, anus, or breast of such a person or any other person. Imprisonment for 3 to 5 years. That fine. For aggravated sexual assault, imprisonment is more than 5 to 7 years. Though sexual assault is a physical contact with the sexual intent but without penetration. But physical contact is there. Punishment 3 to 5. For aggravated, 5 to 7 years. Sexual harassment of the child. If it is considered sexual harassment when a person with the sexual intent utter any word, sound, or makes any gesture, exhibits any object or part of the body with the intent to be heard or seen by the child, makes a child exhibit her body or any part of the body so as it is seen by the person or any other person, shows any object to a child in any form or media for pornographic purposes. Repeatedly or constantly follows or watches or contact a child either directly or through electronic, digital, or any other means. Threaten to use in any form of media, a real, fabricated depiction through electronic, film, or digital in any other mode of involvement of the child is in a sexual act, or entices a child for pornographic purposes. Punishment, imprisonment for 3 years and fine. Use of child for pornographic purpose. A person is guilty for the offense if he uses a child in any form of media for the purposes of sexual gratification, which includes representation of the sexual organs of a child, usage of child engaged in real or stimulated sexual act with or without penetration, indecent or obscene representation of a child. Punishment, imprisonment 5 years plus fine, subsequent conviction 7 years plus a fine. An offense is treated as aggravated when committed by a person in a position of trust or authority of child, such as member of security forces, police officer, public servant, etc. There is a provision for punishment even in an abetment or an attempt to commit the offences section defined in the Act. The punishment for the attempt to commit is up to half the punishment prescribed by the commission of the offence. It is mandatory to report to the police about the offence. Failure to report attaches punishment and imprisonment up to 6 months without fine. Without fine. It is also mandatory by police to register an FIR in all cases of child abuse. A child statement can be recorded even at the child's residence or a place of her choice, and should be preferably done by a female medical officer not below the rank of the sub-inspector if the victim is a female. The child's medical examination can be conducted even prior to registration of an FIR. This discretion is left up to the investigation officer, or in the investigating officer has to get the child medically examined in a government or a local hospital within 24 hours of receiving information about the offence. This is done with the consent of the child or a parent or a competent person whom the child trusts and in their presence. For a speedy trial, the evidence of the child has to be recorded within a period of 30 days. The special court has to complete the trial within 1 year. The burden of proof is shifted and on the accused, keeping in view the vulnerability and innocence of the children. To prevent the misuse of the law, punishment is given for false complaints or false information with a malicious intent. The media is barred from disclosing the identity of the child without the permission of the special court. The punishment for breaching this provision is imprisonment from 6 months to 1 year. Thank you.